Good. Well, the exercise was welcome, sir. Thank you very much. Chairman, in my last contribution, I strayed into part 2 of the bill, and you quite rightly turned me back to part 1. I'm going to address on a clause-by-clause basis several of the issues in part 2 now, recalling first the purpose of the bill, which is, of course, to solve two problems: to make access to justice more evenly and readily available across the industry, and secondly, to avoid a cascade of risk down onto subbies, which the Minister's very aptly described as a problem which has been rife in this industry for too long. What's really interesting, sir, when you go through the clause-by-clause analysis and the amendments which the Select Committee has very thoroughly addressed its mind to, and I'll say again, you know, this is one of those bills where the hard slog's gone on in the back room and the public don't see, I don't think, the amount of cooperation that's occurred between parties to get to where we've got to today. But it's intriguing the level of prescription which is now contained in the drafting, which the committee, if anything, has added to on the basis of submissions. And fair enough, because this is clearly against the background of an industry where end runs occur, shady things happen, people get cheated, and bad practice does occur. And so the law has to be robust and provide remedies for that. One matter that the committee turned its mind to was the issue of so-called ambush claims, claims very quickly brought where the defendant doesn't have sufficient time to prepare a defence. And so in clause 13A, the committee has recommended that the time frame for selecting an adjudicator be shifted. There's actually a typo in the committee report, a commentary, from 2 to 5 working days after the notice of adjudication has been served. Thank you. Likewise, in clause 14A, the committee has recommended adding a new clause to require the information in a notice of acceptance to be prescribed by regulations. And as I say, fair enough. The Minister of the day, whoever that is, should have the power to be very explicit about what information needs to be provided, because by definition, this law has to be robust to a conflict situation where the parties don't agree. And if they can't agree, and if they can't even agree on what information they're entitled to have access to and needs to be provided to the adjudicator, they won't be able to solve the problem. The adjudicator then can't do his or her job. So we support the addition of that power. There are a number of sub-points under 14A, but I don't think we need to trouble the House with the sub-points. Let me flick back quickly to the start of Part 2, clauses 8A, 8B and 8C. It's quite interesting because the committee's both narrowed and widened the scope of the bill. It's narrowed it by excluding second-hand assets and property management contracts under certain circumstances, but it's widened it in respect of the claimed amounts to include liquidated damages, breaches of implied warranties, and construction work already carried out. And it's made it a little more flexible by allowing the parties to agree on single payments as well as part payments. It's then tightened clause 9A to replace the word indicate with the word state in sections 22D and 21.2c, thus requiring the amount of the claim to be specified exactly. The combined effect of those clauses is, as I commented in relation to the regulation-making power, to accept the fact that this is a conflict situation by definition, to ensure that the law is clear about its boundaries and scope, but within that scope to drive quite definitely and clearly to a solution, which is what it is seeking to do with those amendments. Sir, clause 15 proposes, or had proposed, mandatory pre-adjudication conferences. The rationale was to require parties to go through a low-cost, low legality step in the process and escalate gradually. The committee reached the view, after hearing submissions, that that was likely, in fact, to add time, cost and delay because it was a requirement, not an option. And so the committee has removed that requirement by amending the clause that had required pre-adjudication conferences, clause 15. Clause 16.2, the committee has recommended inserting a new subclause which requires an adjudicator to allow a respondent additional time if the adjudicator believes the claim has been served with undue, Mr. Chair.
The Honourable David Cunliffe.
If the claim has been served with undue haste and the respondent has had insufficient time to prepare a response, that's a further measure against ambush claims, and we think it's a reasonable step to take. The right of reply is strengthened in Clause 16A, which is amended by the Select Committee, which allows claimants a right of reply in response to an adjudication response. Adjudicators are free to ignore those replies, but they may raise new issues and material, and it would be proper then for the adjudicator to address those matters. Coming towards the end of Part 2, sir, in Clause 18, there's an amendment recommended to require an adjudicator's determination to be dated. It's a small thing in itself, but I think it's another example of the Select Committee's focus on bomb-proofing these rules so that people can't do an end run around them. And it is a shame when that has to be written into the law, but we accept that that's the world we're in with a conflict situation which has led to these type of claims, and it's an industry where those issues are, shall we say, not unknown. There's an amendment to Clause 28.3 to remove the distinction between payment and other types of determinations. That is, to ensure that an adjudicator's determination is enforceable, whether it's payment related or not, and that's got to be a good thing. And finally, the defendant may oppose entry as a judgment. That is to preserve the defendant's right in relation to any subsequent district court action. And we think that is reasonable. So, sir, summing up, it's clear that the Select Committee has turned its mind in some detail to the drafting of this part. And thank you for allowing me the time to mention most but not all of the committee's amendments on a clause-by-clause basis. Sir, the Select Committee has also worked hard, and the government has worked with it, to look at issues such as a trust or contract payments which get around the problem of the risk passing to subcontractors. And we are supporting this bill because we think that with the SOPs on board, we've got to a reasonable place, sir. It will be instructive to see, once this bill is passed, as I'm sure it will be soon by the House, to see how it beds in, and from a regulations review point of view, we will be interested to see what regulations are promulgated by the Minister under the bill. And I wonder whether the Minister, Mr. Chairman, would take a short call, perhaps just to provide a short outline to the House as to the regulation-making process that he envisages and the scope of those regulations under the relevant clause. I think that would help the committee's consideration, because regulation-making powers are never to be taken lightly. They have to be prescribed in legislation, and the conduct of that regulation-making must occur within the scope and ambit of the empowering provisions. We're hopeful that it will be, and we have no reason to think otherwise, but I think it would assist the House if the Minister could give us a brief outline to that effect. Thank you.